you ever seen one of these before? Yeah, that's what phones used to look like. And did you know that on February 14th, 1876, Alexander Graham Bell applied for a patent on this, an apparatus that could transmit speech electronically, beating out his rival, Elisha Gray, by just 2 hours. Never mind that Gray's design worked better. Shh. Timing was all that mattered. When Gray later filed a lawsuit, the courts awarded the patent to Bell, who went down, of course, in history as the official inventor of the telephone. Hey everyone, I'm JD Houvener, USPTO patent attorney and CEO and managing partner here at Bold Patents Law Firm. Today, I want to talk with you about a couple simple steps that you should take to protect your idea. So instead of going through all the nitty-gritty detailed steps in this video today, if you want to learn it all, I wrote a 7,000-word blog article that covers this, linked down below. I want to talk about the primary points today that you need to know to ensure your idea is protected. On September 16th, 2011, the American Invents Act was signed by Barack Obama. It switched the US inventorship from first to invent to first to file system. The patent applications filed on or after the 16th of March 2013. This forever changed the landscapes for inventors and businesses. So the question is, how do you file first? What steps go into filing a patent application? First off, you need to have an invention, and it needs to be patentable. If you're unsure, make sure to look at some of my previous videos or articles where I dive into what makes an invention patentable and how to invent an idea in 10 easy steps. The next step would be to do a worldwide patentability search. In fact, I've written a blog article about it, linked below. So if you have an idea, the key thing to think about here is making sure you don't lose your rights. In the United States, there's a 1-year grace period from when you must file an invention. If you've disclosed your invention or sold it or even offered it for sale, you only have a year before your rights are completely gone. I hear this story often, and I unfortunately have to break the bad news that if someone has launched a Kickstarter campaign and they've put down all their content on the website about their invention, and more than a year has gone by, unfortunately we can't file a patent application for it. So don't make that mistake. Be sure you're not going to be victim of this statutory bar. The second thing to think about here is inventorship. As an inventor, you got to make sure that you own this invention. And it sounds silly, but many inventors are actually employed, right? They're full-time job during the day, and they're working on their dream or building their invention at night. If those two are close, meaning if your job is related to your invention, you got to take a careful look at your employment agreement to make sure that your employer actually won't own this invention. You don't want to get all the way down the road and start building your dream business if your company's going to be able to make a mistake in ownership in it without your knowing. So, inventorship, making sure you avoid statutory bars. The last thing to think about is eligibility, right? Is your invention something that even fits into the patent realm? Or you've got this idea, but it's still kind of rough. You want to know whether you could even seek patent protection for it once it's brought to fruition. If it's about a natural phenomenon or an algorithm, or if it's merely about, a natural substance or content that is already existent, meaning it's part of the natural language or it's part of the society or the market that's around us, it's likely not going to be patent eligible. You've got to be able to show that there's an inventive step, something truly novel about your invention, above and beyond what's already been done before. You've got to get an opinion from a patent attorney in order to say whether your invention is eligible or not. But based on what I just said, you should be able to tell whether your invention is part of something that's gravity or part of nature, or it's an abstract of something that's already been done before. That would probably lead you to believe that, hey, look, you're not going to take a patent on it, but you can surely have success in the market. But get that opinion first. So you've got to make sure with your idea that you sit down and talk with an attorney about eligibility. Once you're through these sort of initial barriers and you cleared them all, the question now becomes, is it patentable? Could you get a patent on it even if it were to be eligible? And so you have to conduct a detailed patent search. A patentability search consists of two main aspects. One is patent documents, and non-patent literature. When it comes to patent documents, those are patents that have been filed for and published. It doesn't necessarily mean we're talking granted patents here. And what's interesting with the American Invents Act I talked about earlier, That act means that no longer is it just the United States patents that you need to consider, but it's the entire world, right? China, Canada, Australia, Korea, I mean, you name it, all the big, huge players, Europe, surely. All those publications will act to potentially prevent you from getting a patent here in the US if they've ever been published before. The examiner's job is to make sure that if they award an invention a patent, that it's truly the first of its kind in the world. So, before you spend tons of time, energy, and money preparing and filing for a patent application, you're going to want to spend the time up front doing the diligence of conducting a patent search and allow us to do a professional search for you on these patent documents. Now, this other aspect of non-patent literature, this works very much the same as if you're going to try to start a brand or a trademark and conduct your own natural language search. In the same way, do a natural language search on your own invention to see if there's anyone out there in the market that is doing or performing the same type of functionality. You don't want to be able to go through and hire an attorney and pay an application fee and get a year or two down the road if it's already been done before. And not only are you not going to be able to get a patent on it, but you might even be found to be infringing on someone else's patent. So, long story short, patent searching is huge, and it's really the first part of how to bring your idea to market via patent protection. So once you get through the patent search, now we're talking, right? Now this is a novel, patentable invention. Now it's a matter of just pushing the throttle forward and launching. You get to file what's called a patent application, either a provisional or a non-provisional. I've got a separate video that we go through the details of what's the difference between a provisional and non-provisional. I'll save you that right now today. Once you file your application, your patent attorney will work with you very carefully to make sure that it's structured in the right way, that the scope of claim, meaning the written description, the drawings, and the claims are quite broad. We want to try to get you the most amount of protection possible. When that gets filed and submitted to the patent office, now the fun begins, the back and forth, right? The examiner will do their own search. They'll confirm or maybe even deny the search that was done before, and they'll come back with their own potential rejections or objections, and it's our job as your patent attorney to argue on your behalf, to come back with amendments or legal argument to overcome those. Those are called patent office actions, and 1 or 2 are generally expected, but it could take 3 or 4 to get your patent all the way through to granted. Once your patent rights are granted, that is when you have the ability to prevent anyone else from making, using, selling, or importing that specific granted right into the United States. Now, we've also got a separate article I get into about international patent protection that, again, I won't get into in this video. But taking your idea all the way through patent search, application, office actions, through patent granted is no small task, as you can understand. After this, of course, there's the monetization, right? Show me the money. And we have plenty of videos explaining how to make money with patents. I want to just give you a brief highlight here today. You can seek to enforce your patent rights, meaning start building, making, and selling your invention and preventing anyone else from doing the same. That's the classic way of enforcing your rights. You can also make quite a good amount of money licensing your rights, meaning allowing another entity or 2 or several to make, sell, or import your invention on your behalf, or using a royalty payment where they give you payments for every single one that they sell. Of course, there's a third option of outright selling your invention to someone to have full ownership and rights over enforcing it on their own. So I hope this has been a great journey. I'm sure you've got an idea out there. I'm curious to hear what it is. And if you do get a chance, please put in the comments below any questions you've got. I want to be able to get back with you and share with you any of those open-ended questions, anything that's still on your mind. I appreciate your time here today. I'm J.D. Houvener, patent attorney and CEO here at Bold Patents Law Firm. Have a great day, everybody. Go big, go bold.